Bar Rules Series. Professional Responsibility.
Client issues. Formation. The lawyer-client relationship forms when the client reasonably believes that the relationship has formed. Scope of relationship. The client determines the goals and objectives. The attorney determines the means and strategy to accomplish those goals. Fee. Under the ABA, the fee must be reasonable considering the 1. Time required, 2. The ability to take on other work, 3. The usual customary fee in that area, and 4. The attorney's expertise and experience. In CA, the fee must not be unconscionable. Fee agreement. The fee agreement must 1. Detail the nature of the services, 2. The responsibilities of the attorney, and 3. How fees are calculated. In CA, the agreement must be in writing if the anticipated fees exceed $1,000, unless the client is a corporation or former client, or in the event of an emergency. California requires arbitration for fee disputes if requested by the client. Contingent fee. A contingent fee is a fee based on a percentage of the recovery. It must 1. Be written, 2. Signed, and 3. Include terms of calculating fees. Under the ABA, a contingent fee agreement is not allowed for criminal or marital law representation. California allows in a marital case if it does not promote divorce, collecting or modifying an existing judgment. California also requires notice to the client that the fee is negotiable, except in cases of medical malpractice where the fee is fixed by statute. If it fails to comply the requirements, it is voidable by the client, but the attorney is entitled to a reasonable fee. Fee splitting. An attorney may split fees with another attorney, so long as 1. The division is proportionate or joint, and 2. The client agrees in writing. 3. The total fee must be reasonable, or in California not unconscionable. Fee splitting with non-lawyers is not permitted. Referrals. Attorneys are not allowed to pay a fee to obtain a referral. The policy is to prohibit the buying of clients. In CA, a gratuity for a referral is allowed, as long as it is not a quid pro quo, a favor exchanged for a service. Reciprocal agreement. A reciprocal agreement is an agreement between attorneys to refer specific cases to each other. Such an arrangement is allowed, 1. If the client is informed, and 2. It is not exclusive. For example, a family law attorney agrees to refer a wills trust matter to an estate attorney, and the estate attorney agrees to refer a prenuptial agreement matter to the family law attorney. Mandatory withdrawal. ABA requires an attorney to withdraw from representation. 1. If it would violate ethical rules or any other laws, or 2. The attorney's ability, physical or mental state, to represent the client is substantially impaired. California requires withdrawal if the client demands action without probable cause or for a malicious purpose. Permissive withdrawal. ABA allows withdrawal. 1. If doing so results in no material harm to the client, or 2. If the client seeks representation for an illegal or repugnant purpose, or 3. If the client is unreasonably difficult, or 4. Fails a duty as a client. Payment. California allows withdrawal if the client's action is in bad faith. The attorney may not withdraw if the sole reason is no material harm. Duty. The C's. Duty of competence. Under the ABA, an attorney must represent the client with knowledge, skill, and thoroughness. In CA, The duty of competence requires acting with diligence and the mental, physical, and emotional ability necessary for representation. An attorney can 1. Acquire skill through learning or 2. Association with another attorney. Duty of confidentiality. The ABA requires an attorney to protect all information relating to representation, regardless of source. In CA, the attorney must maintain inviolate the confidence of the client and preserve secrets. Exceptions. An attorney may reveal confidential information if 1. The client consents. 2. The disclosure is impliedly necessary for representation. 3. It is reasonably necessary to prevent death, significant bodily harm, or significant financial harm, or to mitigate or rectify harm created by the attorney's services. With respect to preventing harm, California only allows disclosure to prevent death or bodily harm, and not for purely financial harm. Prior to disclosure, the attorney must 1. Attempt to dissuade the client and 2. Inform the client of any plan to reveal confidential information, unless 3. Compelled by court order. Conflict, duty of loyalty. Current clients. An attorney may not accept representation. 1. If the client's interests are adverse to another client, or 2. The attorney's own personal interest, or 3. If the representation is materially limited by an interest or loyalty to another person or third party. California rules prohibit a potential or actual conflict. Exception. An attorney may undertake representation. 1. If the attorney has a reasonable belief, objective reasonableness, that the representation will not be limited in. 2. Obtains informed consent from each client, confirmed in writing, ABA, and 3. The representation is not prohibited by law. California requires informed written consent. But if the conflict is solely due to a personal interest, the lawyer need only give written disclosure. Some conflicts are non-waivable, including 1. Representations prohibited by law, or 2. Where the clients are directly adverse. Former clients. An attorney may not undertake representation. 1. In the same or similar matter. 2. That is directly adverse to a former client. 3. Unless the attorney obtains informed written consent from the former client. In CA, the restriction also applies to situations in which the attorney obtained confidential information from the former client, even if the information was obtained for an unrelated matter. Corporation. An attorney hired by a corporation must act in the best interests of the organization. If an employee engages in wrongdoing or risks injury to the corporation, 1. The attorney must urge the employee to stop the conduct, and 2. If that fails, must refer the matter to higher internal authority. Under the ABA, if no action is taken, the attorney may refer to outside authority. In CA, the attorney cannot refer outside authority, but may withdraw under the rules for withdrawal. Imputed firm disqualification. A conflict that affects an attorney is applied to the attorney's entire firm. But the firm may continue representation if 1. It is based on the attorney's personal interest or a former client while with another firm, and 2. The attorney is timely screened. 3. Does not participate in fees. And 4. Written notice is given. In CA, if the attorney obtains confidential information from the former client, screening does not cure the imputation, and the firm must withdraw from representation. Sexual relations with client. An attorney may not have sexual relations with a client, unless a consensual sexual relationship existed before the representation. California allows a sexual relationship that develops after the formation of the attorney-client relationship, as long as 1. The relationship is not coerced as a condition for representation and 2. The attorney's competence is not adversely affected. Financial assistance. An attorney shall not provide financial assistance to a client, as this creates a conflict between the client and the attorney's personal interest. This requires an analysis under conflicts. The ABA allows the advancement of court costs and expenses in contingency fee cases and for indigent clients. California allows a loan for any purpose, as long as there is a written promise to repay. Business transaction with client. An attorney may enter into a business transaction with a client if 1. The terms are reasonable and fair, disclosed in writing. 2. The client is advised to seek independent counsel. And 3. There is informed written consent. Compensation by third party. Insurance. An attorney may not accept representation where the fees are paid by a third party unless 1. The client gives informed consent. 2. There is no interference by the third party between the attorney and the client. And 3. The information remains confidential. In CA, payment of attorney's fees by an insurance company that selects the attorney to represent the insured is deemed to be no conflict. Duty of candor. An attorney must not offer false evidence. Under the ABA, the attorney must urge the client to correct the false evidence. Seek withdrawal if the client refuses. And if withdrawal is not permitted, take remedial measures including disclosure. In CA, the attorney may seek withdrawal, but disclosure is not permitted. Duty of fairness. An attorney has a general duty of fairness to the tribunal, opposing counsel, and third parties. This includes 1. The duty to obey court rules and comply with orders. 2. An attorney may not provide false evidence or testimony. 3. Obstruct or destroy evidence. Or 4. Engage in improper communications. In CA, an attorney may not use the threat of lawsuit or censure to obtain an advantage in litigation. Duty of communication. A lawyer has a duty to reasonably communicate with a client and 1. Keep him informed of the status and progression of the case so 2. The client has appropriate information to make an informed decision. Public profession. Unauthorized practice of law. An attorney must not practice with a non-lawyer or utilize the services of a non-lawyer who exercises the legal judgment required of an attorney. Prosecutor. A prosecutor must 1. Bring charges only upon probable cause. 2. Reveal all evidence. And 3. Refrain from making extrajudicial statements that may prejudice a defendant's right to a fair trial. Duty to report. Under the ABA, an attorney who knows that another lawyer has violated the rules of professional conduct must report to the appropriate authority. As of August 2023, California also requires such reporting. But with exceptions for confidential information, California also requires self-reporting of disciplinary proceedings. Advertisements. An attorney may advertise the availability of services in a widely distributed public statement, but is not allowed to produce false or misleading ads. Such ads must be labeled as advertisements. Solicitation. An attorney may not solicit 1. In person, 2. Live telephone, or 3. Real-time electronic contact, unless the attorney has an existing relationship with the prospective client.